Thank you. Again, my name is Michael Vonn, and it's about as good as it gets to follow Alan Dutton on that. You have given me a fabulous case scenario to be referencing. Alan was saying British Columbia we had in fact the first anti-SLAPP legislation in the country, and we had it for 8 minutes. And that's perhaps too bad, but on the other hand, it wasn't fantastic legislation. I'm going to talk to you a little bit about the kinds of legislation that is worth lobbying for. What are the essential ingredients that we need in anti-SLAPP legislation to level the playing field? Because of course, a SLAPP is a situation where the process is the punishment. And so to understand how you can bring procedural protections to people who are faced with a SLAPP, you'll recall that when Alan says, there was no evidence against me, but the judge wouldn't strike the pleadings, wouldn't say, no, we can throw this out. The judge's discretion to control their own proceedings on this in terms of what it takes to get something thrown out without anti-SLAPP legislation is almost hypothetical. It doesn't happen. So how do we force the process to the front end to allow a screening or a filtering that would provide some protection? So I just want to say very briefly that in Canada we have some acknowledged thinkers in the field, and that includes the Blue Ribbon panel of legal experts who were advising the government of Ontario in bringing in their anti-SLAPP legislation, which is considered by far the best in the country. As I say, our only claim is that we were the first, never the best. And the other is Professor Chris Tollefson from the University of Victoria, who has been writing on this subject since the 1990s and has really done some trailblazing in the arena for legal thinkers on anti-SLAPP legislation. So here's why you don't want, and this is very counterintuitive, so I've really put this at the front end, why you don't want anti-SLAPP legislation that is dependent on the finding that there is a SLAPP. One of the most blatant weaknesses of our former legislation, the old BC law, was the burden of demonstrating that you were being sued by a party with an improper purpose. So the task of showing that someone's motives are improper is almost impossible to succeed at. It is like trying to demonstrate bad faith. The Ontario Expert Advisory Panel that I just referenced had pointed this out in saying that it's like bringing forward evidence for the judge to read somebody's mind. You can't say what somebody's motives are in the main. So the much better approach is to follow the human rights logic that says that we are not here to investigate motive. We are here to adjudicate the effect. So, just like in the human rights context, if you are bringing a claim of discrimination against me, it is no part of your job to prove that I was trying to be mean to you, right? And it is no defense on my part to say, well, I didn't mean to. The point here is that what counts is the effect on you and not my motive. So similarly, there is a growing consensus that legislation ought to evaluate the effect and not the purpose. And so that would mean that legislation that would be meaningful would have as a threshold question, very simply put, is whether the expression, the statement, the speech at issue that gives rise to the underlying cause of action, the reason why you're being sued, the case that is being brought against you, was that on a matter of public interest? Full stop. That would be the threshold question. So, and just in case you're already speeding ahead and going, how do you prove something is a matter of public interest? Let me assure you, this is not an obscure question in law. It actually is adjudicated fairly regularly, particularly in the access to information context, which Linda and perhaps many people in the room would know. It is often a part of a claim against a discretionary use of non-disclosure for FLI. And certainly it is very much a part of the claim to ask for a waiver of fees for your access request. So in the main, what you're looking at in terms of evidence for that is typically media coverage. That's often the evidence that's used to say, look, this is a matter of public interest, it's being covered in the media. That's fairly common. So that would be a burden that would not prove onerous in respect of SLAPs. So if the matter is squarely focused on the question of, is the discussion here that is at issue for the underlying claim, is it a matter of public interest? And if that can be successfully demonstrated, as I say, a very low burden on the person who is making the allegation, then the onus shifts. Your job is temporarily done as the person who is being slapped, and it shifts to the party who is suing you, the people who brought the underlying cause, and that party now has to demonstrate to the court that their claim has substantial merit and that there are substantial grounds to believe that the defendant has no valid defense. So essentially, you're truncating the trial and you're reversing the onus at a very early stage of the process to have the person who is suing you demonstrate the bona fides of their claim. As we say, these are claims that quite often are not even intended to succeed, just intended to sound like they might to get over the threshold of starting the process is the punishment. So truncating that into a very clear public interest demonstration and then reverse onus is how you build in a protection. That is the screen. That is the filter. So if you do that, you get by the screen and the filter, you have to remember that if that process is just as onerous as a regular trial, well, you're still being slapped, right? So you have to make sure that what it is that you're proposing has an ability to provide a minimum burden to the slappee. So you're looking for procedural protections that would include very short deadlines for the party that you're opposed to reply and to file their materials. You want an expedited hearing. It's got to happen fast. It can't happen a year from now. Again, while all your resources are being drained, while you continue to worry, while the chill is impacted. And it has to be, in terms of an expedited hearing, it has to 100% fully and automatically suspend the underlying action. You don't want discoveries occurring, et cetera, so you're essentially fighting on two fronts. You want this to be the front where the action comes, and again, expedited, shortened procedural protections. Okay, so with that in place, there's still the question of how to create an economic disincentive to bring the slap in the first place. Remember, slaps are usually big resources suing little resources. So you have to provide an additional incentive, not just that we have this new procedure that's going to reverse the onus and you're not going to be able to meet the test. The economic disincentives could include automatic full indemnity for costs of the successful plaintiff. So they have to pay your costs, your lawyer who showed up, all the costs in relation to that. But also an automatic award of compensatory damages for the breach of your expressive rights. For that chill, it builds in, again, a reverse tort. I am now suing you for the wrong of breaching my expressive rights. It also includes, or could include, should include arguably, the possibility of a discretionary award for punitive damages where the court is in fact satisfied that the plaintiff was attempting to punish or to silence or to intimidate the party that they were suing. So remember, in the old British Columbia legislation, that's what you needed to show to get in the door for your anti-slap procedure. This, we're saying, is more appropriately placed at the level of discretionary punitive damages. You wouldn't have to be able to make that finding in order to have a successful claim get your costs covered, get the case dismissed. Finally, we say, in terms of what the package should look like, that there should also be a substantive measure that deems communications made in the public interest to be occasions of qualified privilege for the purposes of claims of defamation. Defamation, again, as Josh was saying, are not the only potential slap fodder, but they are the go-to slap quite often for various situations. So advocating reform in that case, because it's a very plaintiff-friendly kind of tort to pursue. So you try to immunize, in the law of defamation, certain public interest communications from liability. So there's one last component that I want to talk about, and that is that you also need what is called dismissal with prejudice, which means that the law would prevent the plaintiff from amending their statement of claim unless the interests of justice required it. So this means that a dismissal under the Act, if you had pursued this process through the Act, would ordinarily be final, and that the plaintiff can't just relaunch the suit with an amended statement of claim, right? That would be no protection whatsoever if they were able to change a couple of things and do it all over again. So, so the notion of building in a presumption of finality would be a key component of how you would shape those protections. So summaries of really everything that I have said exist on our website, but they're going to be better. They're going to be better because it's part of the campaign for 2017 that we really want to pursue to help shape what the discussion looks like for asking the BC government for these statutory reforms to level the playing field for expressive freedom and political participation in this province. We are now the most populous jurisdiction with no anti-SLAPP legislation in the country. And we have to basically formulate the materials to make the case very forcefully. As I say, it's curious that we had this anti-SLAPP legislation for so little time. It was going to be a little bit of an uphill battle to convince the government. The last time I remember being in an exchange with the government on this question, they provided the wisdom that they thought that the courts already have the inherent jurisdiction to ensure that non-meritorious complaints are not pursued. That is a pile of hooey. That is simply not the case. We have demonstrated this time and time again, and it takes no credence of the chill that occurs in addition to what you can point to in court processes. So we are looking forward to very, very much helping to stand by various allies to bring this forward into a concerted effort to find ourselves with the kinds of procedural protections that other jurisdictions in Canada enjoy. We're about to see how well they work in Ontario, but it's very clear that this is more than needed. It's well overdue, and the time is now. Thank you very much.